Hi, folks. This is Kid Malek. Um, Today, I'm going to talk about this recent case that came out of the Ohio Supreme Court called Klein versus Precision Excavating and Grading Company. Um, and I guess the reason why I'm going to talk about it is because this actually has come up a few times, the kind of factual situation in this case, and so it might be relevant to your situation as well. So that's why I'm bringing it up. But basically, the facts in the case, or this is the kind of situation. So you get injured on the job, and then you're taken off work. You're certified temporarily and totally disabled by your doctor, and as you know, as experts in the labyrinthian process of the BWC, you have to be certified by your doctor in a Medco 14 in order to be entitled to receive compensation. So, anyways, this person's certified, um, and so they got injured in Ohio. They're certified off work. So, for all intents and purposes, physically, they're unable to do the job that their former position. So they can't do that work, and so the idea being that if you're in Ohio and you can't do that job, then theoretically, let's say that particular company that you're working for, like, went out of business or disappeared or terminated you for unjustified reasons, you would still be entitled to TT because you can't do that kind of work. So if you were doing logistics work at, say, Amazon, and somehow that job ended for whatever reason that wasn't a result of your voluntary act, then if you would still be receiving TT because physically you're still unable to work. So you can't physically, it's an impossibility. You can't physically go out and do a job at another logistics warehouse or another job using the similar kind of movements or activity. So if you're doing like a logistics type of job, you wouldn't be able to do that kind of work. If you're a construction worker, you wouldn't be able to go work at another construction job because of the nature of your injury. So, and usually the usual thing is they have this concept, this judicially created concept called, voluntary abandonment of the the workplace or workforce. So, and the idea is, so there's voluntary activity and there's involuntary activity, and so an involuntary act would be you get injured at work. So you get injured at work through no fault of your own, and that boots you out of the workplace because you can't do the job. Well, that was something that happened, and obviously you didn't choose to be injured unless you're crazy. So you got injured, and so you had involuntarily abandoned the workforce. So you did something involuntarily, severed the connection to the job. So there's that. Now there's voluntary abandonment from the workforce, and that's something that you do. Like if you quit, that's an act that you do yourself. You quit, you took a voluntary action, and you quit. If you do something that caused you to be fired, you flip off your manager. You're like, F you, I'm sick of this job, and your kid is a little brat, and whatever you do, you get fired. That's, you did something voluntarily, and you took a voluntary act, you got terminated. So something happens like that, or even if it's something like, a lot of times you'll see people getting the voluntarily abandonment thing thrown at them when what they call it the no call no show. So a lot of jobs have, you have to, if you have 3 or more no call no show marks in your employment file, then they have grounds to terminate you. And so that's one that people get caught up a lot in. I see, or it seems to happen often enough that I tell people, like, hey, if you got injured, just keep in touch with your employer until you've been taken off work by a doctor. Just let them know, keep in touch, and let them know what's going on. Because what will happen is, You'll get injured, you'll go to the hospital, and the doctor will write you off or something. And you're not sure how long maybe the doctor only wrote you off for 2 days, because that's often what they do from the hospital. So he writes you off for 2 days, and then, but you're not ready to go back on the third day. So you don't show up at work, so the no show, and you don't call them up. You don't say, hey guys, I'm still having problems from, my work injury. I'm not going to be able to make it today. And then the fourth day, hey guys, you don't give them a call, you don't show up, and let's say you go back to work a few more times, and then a week or two later, you wake up and you're like, oh man, I can't work today. You don't call and you don't show. So now you've gotten 3, and now you're fired. And you can look at it like that way, or you're terminated. The first 2 that you got was kind of really in close proximity to the work injury, the time that you're taking off. But it was that third one that happened more distance, which caused you the problem. So anyways, that's the idea of voluntary abandonment. You do something that severs the work, the injury from, the reason why you're not working. So it has basically, and the effect ultimately that has on your claim is you'll still have a claim, and you'll still get medical treatment paid through the claim. But if you're trying to get compensation, if you're found to have voluntarily abandoned your job, then you have to do something to get back into a job in order to be found to have fixed that problem. So if you've been found to voluntarily abandon your job, then you won't get TT or temporary total compensation and all that compensation. And if you're not able to work, that's a problem, right? Because you don't have any income coming in. If you could work, it's not a problem because you just get another job. So in this case, the wonky thing with this case is, and remember the idea is, you do something, you sever. So let's say you leave the job, and then you move to another state, right? And you've quit your job and you leave to another state, and at that time, when you leave your job and go to the other state, you're still, you're still physically incapable of doing the job, or the type of work that you did when you got injured. So theoretically, you're going to go to the other state, and the idea is, you're going to try to find work there if you can, and that's what the person did in Klein versus this precision excavating company case. But what he ended up doing is this injured worker ended up going from Ohio, and then he left to Florida because I guess, I don't know, I don't entirely blame him wanting to go to Florida if it's the winter time, because it's warm, and everybody loves Disney World and Universal Studios, but I presume he didn't go there for that. He went there for work. So but the point is, he went there, and his physical injuries still prevented him from being able to work. So, and by all intents and purposes, if you're unable to work and you're certified, then you should be paid temporary total disability. And it went through the administrative process, it went through the 10th District Court of Appeals, and then ultimately the case was brought up before the Ohio Supreme Court. And basically the court said, and in this case, the guy was unable to work because of the chest injury, but they say, it had nothing to do, his leaving to go to Florida and his work injury were two distinct things. And therefore, irregardless of whether he could work or not, he took some voluntary action, and I guess it's unfair to the employer to continue to pay him TT when he's living in Florida trying to find a job. And I guess that's so the thing is, I guess the law is, if you're injured and the idea is you want to continue receiving TT, and you just quit the job to try to find a better thing or a position that would work for you, that it's not going to happen now. So if you're like this guy and you're injured, you're certified to receive temporary total disability, and you quit, and then you go to some other state to find work, then you have been found to have voluntarily abandoned the workplace, and therefore your entitlement to temporary total is severed, at least at that point. So yeah, because they basically in that case said claimant voluntarily quit for reasons unrelated to the allowed conditions, even though he was already disabled by them before moving to Florida for better job or opportunities. And in the Supreme Court basically said, they based their decision on, they said there needed to be a causal connection between the lost wages and the allowed conditions, and then even if that connection exists, subsequent voluntary abandonment of the former position for reasons unrelated to the injury breaks the connection, and temporary total is not payable thereafter. So yeah, again, it's one thing if you're able to work, but it's another thing if you're unable to work. And what difference does it make where you are physically? And there's this other idea, is there's case law, and this is where it gets controversial, and this is where a lot of people have problems with this case, is that there's case law, or there was case law, and some of it's still good, some of it's not, that says you can't voluntarily abandon something if you're incapable of voluntarily abandoning something. So that logically the idea is, if you've been certified temporarily totally disabled, so you're found to have involuntarily abandoned your position of employment, logically you can't then voluntarily abandon, because you're already out of the job, you already abandoned the job on the involuntarily means. How do you go back and then voluntarily abandon the job? See what I'm saying? It's kind of a weird concept, but it's you have two states of existence, involuntarily and voluntarily, and you're already voluntarily abandoned. You've already involuntarily abandoned the workforce because you had the work injury and you're certified by your doctor. Now, how can you then go back in and say you voluntarily abandoned the workforce? So that's the problem. So, because usually the voluntary abandonment stuff comes up with these termination things and whatnot is when somebody they're not completely removed from the workforce, so they're working with restrictions, and then they violate the no call no show or something, or they do something at work. But I guess Cordell's still good, so that's good, I suppose. That's the pot case. The Gross 2 case, I guess, is good. Gross 2 is the case where the kid, where the court said you can't voluntarily abandon your job when you violate when your violation of a safety rule happened contemporaneous with the injury. In that case, it was a kid working at Kentucky Fried Chicken or something, but he was cleaning out the hot grease, and you're supposed to do something specific in cleaning the hot grease, and he didn't do it, and that was a violation of one of their specific rules. And however he tried to clean this thing, he ended up getting burned, and so that was his workers' comp injury, was getting burned, and then he also violated the rule at the same time. And so the employer in that case tried to say, hey, he shouldn't be entitled to temporary and total disability comp because he voluntarily abandoned the workforce. But they said, nah, pre and contemporaneous conduct cannot be used to find that somebody had voluntarily abandoned. So it has to be conduct after the injury. So anyways, so the bottom line is, if you got a job and you quit, and you're certified temporarily totally disabled, and you move to another state, then you won't receive comp. But I suppose that it really doesn't matter. I guess the fact that guy moved to Florida is not so relevant. I guess the issue is if you quit, and then you're severing that entitlement to comp. So things to think about, and that's the reason why you want an attorney when dealing with these workers' comp claims, because these things come up people think, well, I got injured, I should, get this and that. I mean, you should. I agree. If it was Kip's workers' comp system, it'd probably be a little bit more fair, maybe. I don't know. But there's a lot of rules involved in this whole thing, so it's good to know the ins and outs. Now, here's the thing. So this guy, and from my experience, and I've had people where this has happened in their claims where they've gotten injured and then they've resigned. So in writing, they submit their resignation. So they submit their resignation, and then, I don't know, they can't find another job or whatever, and so they make a request for TT, and then the Industrial Commission says no, or the BWC says no. Some ways to remedy that is you try to get a job, and if you try to do the job, and let's say you get a job at Myers or Walmart or wherever after your work injury, if you do the job and you can continue working, awesome. That's a great outcome, because you're always going to do better working than on workers' comp. That's just the way it is. But let's say you go to Myers and you try to work for, a few weeks, a month, a couple months, and it's just, you feel an exacerbation. You feel that the original pain and issues from the original work injury, just they come back and things get worse. At that point, if your doctor, you go to the doctor and your doctor takes you off, you will have basically re-entered the workplace. So you kind of erase that involuntary abandonment issue, and then you maybe renew your at least entitlement to TT. It doesn't mean you're going to get it. You still might have to go to a hearing, which you probably will. You'll have to convince them that you should get TT. But yeah, that's the way it works. So yeah, I thought it was an interesting case. It definitely looks like a case that isn't really good for the injured worker. You have these cases that chip away at the what injured workers are entitled to. So I think this is one that is chipping away at that. But that seems to be the tendency, the trend, anyways. A lot of these, when things go to the Supreme Court in Ohio, a lot of times it seems like they go against the injured worker. I think more so than not. I could be wrong, but so that's Precision versus Excavating and Grading Company. So, anyways, yeah, if you have any kind of, if you have questions or you have work injury, this is Malek. We do free consultations, so you can present your issue. We'll listen to it. If there's something way we could help you, we will try to. If we could, if we could just say, hey, do this, and you don't need an attorney, that that's an option too. But give us a call, 614-444-7440. And again, my name's Kip, but there's other attorneys here: Doug Malek, Jim Malek, Ed Malek, Ben Churchill. And so yeah, if you have a workers' comp injury or any kind of serious injury, give us a buzz and we'll try to help you. And otherwise, thanks for listening to this.